Good morning, everyone. It's your friend Rick. It is Saturday, September 2nd, 2017. Sorry about that. If you need to contact me, my email is rick0327@me.com. For people new to my channel, I do not make phone calls, and I do not receive phone calls. It's just a policy I have. It's not that I don't like you. It's nothing personal. It's just I didn't have very good experiences with it early on in my helping people on this channel. So I find it's better that we handle things via email. Okay? Because I can't get caught in a 45-minute conversation by email. Alright? So if I entertain 5 or 6 phone calls a day, and they always go into 45 minutes, because I got to hear, the frustration. I got to give the courtesy of listening to people venting, because I'm a person that understands, so they just to get it off your chest. So that's what usually happens in these phone calls. So I stay away from it. All right, I'm gonna do a video probably tomorrow morning. I'm gonna show you had a subscriber in Ohio. He filed the Writ of Mandamus. All right. They're scared of this now. I'm telling you, they're scared. So he filed it against the judge, because the judge was doing his, this is the guy that I think I was telling you guys that the judge was like, well, my jurisdiction is I was a licensed attorney, and now I'm an elected judge. I have jurisdiction, his chest out with his black robe. Except we know that jurisdiction, right? Where's jurisdiction come from? Evidence. Okay? Evidence of what? Of an injury in fact caused by some conduct. Now, this is going to create problems for these petitioners that are county child support collection agencies. And they're a fiction. How are they going to prove an injury in fact? See, only a live human can be injured in fact in court. Okay? So this presents a lot of problems, and this is the reason why we're sending in paperwork before going to court, and it's causing them to be frustrated. There's a lot of lying going on. So the guy filed the Writ of Mandamus, and you know what response we got? We got a 7-page motion for dismissal by the district attorney. I guess the over there, I have a feeling it's the district attorney's office that handles the child support. And in every state, there's a different agency. New York State, it's the temporary and needy family, or the temporary disability. That's the parent. That's the executive agency. Texas, it's the Office of Attorney General. Every state is different. So apparently, in the county where he resides, it's the district attorney's office. So an attorney from the district attorney's office filed now, by the way, he filed it on behalf of the judge. That creates a few problems that we addressed. Okay, but right away, now think about this for a second. All we're asking the judge to do in the Writ of Mandamus is show evidence that the judge relied upon. Pretty simple. We're not asking for anything difficult. I mean, I know he was a lawyer, and I know he was a judge. He's an elected judge. But where is the evidence? Now, this proves that this works, because why are they going to go to the trouble of fashioning a 7-page motion to dismiss with all kinds of BS citation? Of course, they do the old, well, we'll do it, what they worded, because in the Writ of Mandamus, we point out that the judge cannot be impartial. Why? Because the judge, his salary is being paid by the money deposited from the incentive monies under 48 USC 658A, Title 4D. Now, if a judge is creating these orders to order you to pay through there to the state system, then the state is reimbursed or receives a lot of money. Is it unreasonable to believe that there's some type of, orders coming down from high in the state government, encouraging judges to force as many people to pay by income withholding? Is that unreasonable? No. We know that that's what's going on. So the judges know this. The judges know that their pensions are paid by this. The judges know their benefits are paid from this money. Okay? It's a big problem for judges. That's why judges should not be handling these cases. So the response from the district attorney's office was, well, he's implying that the judge is not impartial because, and he was trying to write it in such a way as like it's doesn't make any sense. But then why is he addressing it? You understand? If it's not something to be taken serious, or it has no effect on the case at hand, why are they addressing it? Because it's true. That's why. Okay? So they went to all this trouble to state that the subscriber failed to state a claim in the petition for writ of mandamus, and then they admit in the dismissal papers that a writ of mandamus can be used for a higher court to order a lower court or a tribunal to perform a duty required by law, or required as part of their duties, a ministerial duty or a ministerial act. That's what we're trying to do. Okay? A judge is only supposed to render a decision based upon evidence or competent testimony that he or she sees and hears, not what he or she has been told by a fact finder, one of these fake judges. Okay? That's called hearsay. All right? So we responded with, why do we have to state a claim for a judge to do his job? Why can't the judge just show us the evidence? What's the problem here? Okay? Is it not part of the judge's duty to show evidence of jurisdiction when demanded? Is that part of jurisprudence? Of course it is. Okay, and it's an accepted fact, held many times in many courts, federal courts of appeals, lower courts, Supreme Court, that when a court acts without jurisdiction, the order is void. That's it. That's what we're stating. And we're being met with a 7-page motion to dismiss. Okay? So, what does that tell you? That tells you it works. It tells you we're on the right track. Okay? And we're getting a response. Okay, remember, this is not easy stuff. They're not just going to go easy. Again, remember, it's all about boxing them in. Now, if we didn't do the writ of mandamus, the case would be over. Right? How are we boxing that judge in? Writ of mandamus. You must show evidence of jurisdiction because there is none. I cannot find it. I'm asking you to show me. Right? So, it works. And this is why we have to do this. Okay? This is why we're going the path we're going. Because it's not going to be easy. And, listen, they're doing their push-ups. Okay? They're doing their push-ups. They're doing their sparring. These people know what we're doing. Okay? They're all talking about us, these judges and such. Okay? But see, I do things differently. I'm all about making the case. I don't fall into this like sovereign citizen stuff and all that stuff. I do things my way, but my way seems to be working. Okay? All I'm trying to do is make a case that you don't have any evidence of jurisdiction. Really simple. Without evidence of jurisdiction, your orders are void. Okay? I've told you guys, I'm always attacking the order of support because I know the orders of support are void. And what we have to do is just box them in by forcing them to show the jurisdiction that would make the order valid. Remember, it's void because they don't have jurisdiction. All right? 9 times out of 10, they're issued by a fake judge, one of these non-judicial persons. That should be fairly simple. Okay? That's writ of mandamus as well. All right, so we're on the right track. I'll do the video tomorrow showing you guys, what it looked like. I'll show you the 7 pages. All right, because remember, another YouTuber said the writ of mandamus doesn't work. It's, doesn't work. I don't know. I don't know why a district attorney would waste 7 pages of nonsense to try and disprove a writ of mandamus, which, by the way, is a common law writ. Okay? And they're trying to use this statutory stuff. All right? It's a common law writ. And here's the thing about common law writs. Writ of habeas corpus, writ of quo warranto. They cannot create statutes to subjugate, to subvert a writ. They cannot do it. Just like they cannot create a statute to subvert your right to a trial. Okay? The Supreme Court says in a landmark case, Murray Lessee versus Hoboken Land Development or something like that. It's an 1856 case. All right? And the Supreme Court says that due process is a judgment by a jury of peers. That due process is the law of the land, synonymous with the law of the land. And what is that? A judgment of your peers. New York State over here, we have Article 1, Section 2 says the same thing. Okay, so we're on the right track, guys. All right, and please, some of you got to do your homework. You got to put the time in. All right, I can't be there for everything. I'm trying to help you. All right, but a lot of you got to learn this stuff. All right, again, some of you guys are still confused with who the petitioner and who the respondent is. Okay? You're only a petitioner when you're petitioning the court. You're not petitioning the court when you're filing a motion. Okay? If you're filing a motion to vacate an order, you're the respondent. The petitioner is the petitioner on a support order. That's it. It doesn't change. Okay? When are you a petitioner? When you file a writ of mandamus, when you got to hand over some money, when you got to pay your extortion fee to the courts. Because that's all that is extortion. Okay? The court's supposed to be open for remedy. Except if you're broke, how are you going to get a remedy? Alright guys, so listen, I'm going to shut the video down, and I'll talk to you guys tomorrow.